Major breaking news. Judge Roger Benitez in the Southern District of California, United States District Court, has declared that California's quote-unquote Billy Club law is unconstitutional under the Second Amendment. Specifically in the case of Fouts versus Bonta, a major win for the Second Amendment and for the attorney out there, Alan Beck. Congratulations to the plaintiffs and Alan Beck and to the plaintiffs team out there. Big win. We're going to break it down in just one moment when we come back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many books, including Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Stay tuned for a big announcement of a new book coming out very soon. All right, folks, major win. Judge Benitez does it again. Applies the law, really, is what he does correctly, right? He is actually one of the few judges out there in a blue state that applies the Constitution as it's written and Supreme Court precedent as it is laid out. In the case of Russell Fouts versus Rob Bonta, the so-called Billy Club law, which bans the possession of a billy, which is not even defined apparently under the law, has been declared unconstitutional as violating the text of the Second Amendment. The right of the people to keep and bear arms shall not be infringed. As we've talked about in this channel before, it is crystal clear that arms in the Second Amendment does not just limit itself, is not just limited to firearms. We know that at the most basic level because arms consists of a lot more than firearms. And we know from the 2016 Supreme Court decision of Caetano versus Massachusetts, where stun guns were found to be arms, and stun guns are not firearms. So that is exactly what Judge Benitez said here. He points to the Caetano case and discusses it, and then he respects and points out that obviously billies are arms. The parties agree that they're arms, and because they're arms, the burden shifts to the government to show that, among other things, they're not in common use by Americans for lawful purposes. And he also gave the government an opportunity to come forth with historical analogs, which he did not need to do. But as a district court judge, it doesn't hurt to show your own work, to show that whether you apply the Heller in common use test, which is the law of the land, or even if you wanted to give the defendants a chance to look at historical analog laws, in the context of this case, they had no hope, no how. And you'll see it went really, really, really bad for California. We're going to get to that in just a couple minutes. To begin with, this is what Judge Benitez said as he declared that this law was unconstitutional and should hereby be enjoined and declared unconstitutional immediately. This is what he writes in his conclusion. The Second Amendment protects a citizen's right to defend oneself with dangerous and lethal firearms, but not everybody wants to carry a firearm for self-defense. Some prefer less lethal weapons. A billy is a less lethal weapon that may be used for self-defense. It is a simple weapon that most anybody between the ages of 8 and 80 can fashion from a wooden stick or a clothes pole or a dowel rod. One can easily imagine countless citizens carrying these weapons on daily walks and hikes to defend themselves against attacks by humans or animals. To give full life to the core right of self-defense, every law-abiding responsible individual citizen has a constitutionally protected right to keep and bear arms like the billy for lawful purposes. In early America and today, the Second Amendment right of self-preservation permits a citizen to repel force by force when the intervention of society on his behalf may be too late to prevent the injury. The founders of our country anticipated that as our nation matured, circumstances might make the previous recognition of rights undesirable or inadequate. For that event, the founders provided a built-in vehicle by which the Constitution could be amended, but a single state, no matter how well intended, may not do so, and neither can this court. Plaintiffs in this case challenge California Penal Code 22210 as it applies to a billy. It is declared that the prohibition on a billy unconstitutionally infringes the Second Amendment rights of American citizens, and it is hereby enjoined. Powerful language by Judge Benitez. Again, major victory for the Second Amendment here by applying the Heller and the Bruin test. Again, Bruin is simply a reiteration of Heller. Bruin cites the Heller 80 times favorably. That's by my count. And of course, Heller deals with arms bans. And because the billy was banned by California, guess what? It's an arms ban case. You apply Heller. Nevertheless, Judge Benitez went ahead and said to the state of California, go ahead, if you want to submit a bunch of historical analogs and try to persuade me that there's a national long-standing tradition going back to our founding period of banning billy clubs or billies or clubs, have at it. I'll take a look at it just to see if there's anything there. And it turns out there was nothing there. In fact, the state submitted 250 alleged laws that justify their position according to them. And Judge Benitez says, yeah, no way, no how. Among other things, he said that the laws that the state had submitted, in addition to the fact, the truth is he didn't have to look at any of this because the Supreme Court already did this work in Heller in an arms ban case and said that any arm that is in common use by Americans today for lawful purposes cannot be banned. Judge Benitez points this out and says that obviously they cannot be banned under Heller. He then, by the way, goes on to say that all sorts of uses of weapons, whether or not they're fired or actually used, is still in use. He makes the point that we've made on this channel repeatedly, that the mere possession of these arms, having these arms at the ready, displaying them potentially, just carrying them in and of themselves, all of which constitutes a use. You don't actually have to show that they're used all the time by hitting somebody over the head for self-defense, any more than you don't have to show that people pull triggers every day for self-defense with a firearm, and Judge Benitez makes this point. He then goes on again, as he distinguishes these 250 laws, he makes several points that you probably have heard about on this channel. One of the critical things he says is that it is crystal clear that the relevant time period for understanding when a historical analog is relevant to interpret the Second Amendment. That's during the founding period. And just to jog your memory, the way this works is you look at the text of the Second Amendment as defined by the Supreme Court. Okay? Arms are defined by the Supreme Court in Heller as anything that can be used offensively or defensively. Billies could obviously be used offensively or defensively, so they are arms. There was no dispute here by the government of California, the state of California, or by the plaintiffs that the plain text was satisfied here in the sense that an arms ban applied here. So textually, the Second Amendment was being violated. So that means the burden shifted. The burden shifted to the government of California and for the state of California to come forth to show that as a matter of history, meaning there was a long-standing historical tradition of regulating, or in this case, banning these kinds of firearms going back to the founding. Now, of course, that's not simply possible because the Supreme Court's already looked at this and said you can't ban commonly owned arms. And even if you do the work again and look at all the historical analogs the state came forth with, turns out none of them helped out the state for three major reasons. And then I'm going to get to a shocking comment. Judge Benitez really raked over the coals the experts proffered by the state and also the state's characterization of the evidence. We're going to get to that in just about 3 minutes. To begin with, though, Judge Benitez says, first of all, any law that was an English law, because the state of California cited to laws from England going back to the 1300s, he points out that's way too soon because the entire point of the American Revolution was to repudiate English law by and large, to repudiate a lot of the English restrictions on rights. We did not want to be England anymore. We wanted to be American. So the fact that they're relying on English law means it might be relevant, but as a general matter, it's not. So he basically dismissed most of those English laws, especially those that went back to literally the 1300s. You heard me right, the 1300s England, as not being relevant to the meaning of the Second Amendment and justifying the ban on these billy clubs. Then he talks about, you're going to find this very interesting, folks, because he then points out that in the early 19th century, when the founding fathers all passed away, anything after that is simply too late, really, to give us any guidance. It's possible that evidence after the founding fathers pass away could be relevant in the sense that it confirms or affirms the 1791 meaning of the Second Amendment, but to the extent that you have later history after the death of the founding fathers, anything you have that's after that period that's contradictory, inconsistent with the text of the Second Amendment, means that it should be discounted and rejected. We see this over and over by the U.S. Supreme Court, not least of which was in the First Amendment context in the Espinoza versus Montana case several years ago, where Chief Justice John Roberts points out that even though there were 30 states that had certain restrictions on religious activities in the late 19th century, that was not enough to justify the violation that was being alleged of the First Amendment in 1791 by the state of Montana in that case. And therefore, those late 19th century historical analog laws in the First Amendment context were rejected as too late. Now, what's interesting here is that Judge Benitez makes a point that we've made quite a bit on this channel about the dates of death of the founding fathers. Specifically, what he says on page 12 is this, quote, "Of the 39 representatives who signed the Constitution in 1787, none were alive 50 years later. Both Thomas Jefferson and John Adams died on July 4th, 1826. James Monroe died on July 4th, 1831. James Madison, known as the father of the Constitution, lived the longest, passing away in 1836. So again, we've talked about the dates of the deaths of the founding fathers, and it's important to know that because that really locks in the last kind of years that could conceivably be relevant to understanding the 1791 Second Amendment. Anything after that is simply way too late, except, again, as a confirmatory analytic, confirming the 1791 understanding, but to the extent later historical evidence contradicts the meaning of the 1791 understanding, then that is rejected and the text controls in all respect. But let me carry on. Then Judge Benitez goes on and talks about a situation where a female, and he draws an analogy to the Caetano case. Just to jog your memory, in 2016, Caetano versus Massachusetts involved a woman who simply possessed a stun gun and brandished that stun gun to a ex-boyfriend that there was a domestic restraining order against. He came to visit her. She brandished the stun gun and said, "Get away." He left, but ultimately the police found her with the stun gun, and she was arrested because under Massachusetts law at the time, the mere possession of a stun gun puts you in prison, and she was convicted of the crime. It went up to the U.S. Supreme Court. The Supreme Court decided in a per curiam decision that obviously stun guns were protected arms, and ultimately was remanded down for a decision by the Massachusetts Supreme Court, which is technically the Superior Court. Well, I won't bore you with the details, but the Supreme Court of Massachusetts, for all intents and purposes, said that, of course, these stun guns are protected arms, and the Massachusetts law is unconstitutional and cannot be enforced against Ms. Caetano, and she won her case. So by analogy, what Judge Benitez does here is he talks about a hypothetical woman who is walking through a gang-infested area where there's been a lot of violence, where rapes have occurred, where murders have occurred, and robberies and assaults and so on, and points out that she carries a billy or a baton for self-defense. And what he says basically is, isn't it hypocritical? It's ironic, and if not hypocritical, that the same police officers that carry billies and batons for their self-defense wander into the area. They see her carrying this billy club, and they're carrying a billy club, and she's carrying the billy club, and yet they arrest her and lock her up and put her in prison in the same way they did with Miss Caetano, even though all she's doing is carrying this billy club peaceably with no threat, having done nothing with it, and yet the police get to carry it, and she doesn't get to carry it, and she gets arrested and put in the back of a police car and gets a record. And he says that is clearly not appropriate in that illustration. He points out and says that if basically, for all intents and purposes, what he suggests is that the police can carry this for self-defense, why shouldn't the young girl carry it for self-defense as she's walking home at night through a dangerous neighborhood? Now, I just want to wrap up with something that was sort of shocking in this opinion. If you look at pages 17 through, I think, 20, there's a discussion here how Judge Benitez basically calls onto the carpet the state of California and their experts for how they characterize some of the historical evidence. This is what he writes. This is what Judge Benitez writes. Only 7 states in the 1800s had billy restrictions. So why does the state and its expert witness say 14 states had anti-billy club laws in the 1800s? The sentence is inaccurate. The assertion is misleading, and it is important. By giving the impression that 14 states had adopted anti-billy club laws in the 1800s, the state implies that state laws were numerous enough to represent a historical tradition. A different story is told by the state's own list of laws. A different story is told by the experts' own data. The problem with the 14 states claim is that it is actually half that. Where does one find these other so-called state laws? Now, he goes on to say that he could only find 7 state laws and then 7 other laws adopted by apparently municipalities and localities. And he basically says that the state of California is misrepresenting the historical evidence, and he caught them. This is how he sums up that section. It's really a killer point and very embarrassing. In my opinion, if I were the expert involved or the state of California or the lawyers, I'd be very uncomfortable with the fact that Judge Benitez made these findings. It would certainly concern me as to what happened if it turns out Judge Benitez is right, and I'm presuming he is because he had to look at all this to issue this very long, powerful decision. So this is what Judge Benitez goes on to say about this sleight of hand, what he calls a mischaracterization by the attorneys and by the state of California. This is what he writes elsewhere in the opinion. It makes it difficult to properly perform the Bruin analysis when the state's expert who has studied gun regulations for 30 years is imprecise in his language and when the state's briefing employs a mischaracterization. After all, the subject of the regulatory what and when is the central historical tradition inquiry after Bruin. More importantly, it is the government's central burden to show a national tradition of regulation by reference to state laws and court decisions in effect during the most important historical time period. Wow. Really tough stuff, indicating that he considers what the state of California did here to be very bad, to the point where he calls them out in this opinion. Now, if I were the state of California, I'd be very uncomfortable with this because, again, once something like this occurs with respect to you, it now often can raise questions about you in the future, how credible you are, how truthful you are, how much credibility will judges and others give your opinions or your views. So if I'm the state of California, I'm very nervous that Judge Benitez wrote this in opinion that is going to be read by other lawyers and other people and members of the press and, of course, by other judges and other courts that may rely upon arguments made by California about the history involving firearms in the United States. All right, folks, so there you have it. Congratulations to Russell Fouts and the other plaintiffs, to Alan Beck and to the other lawyers out there for a big win. We'll see what the Ninth Circuit Court of Appeals does out there in California. One just doesn't know what they're going to do. I suspect it will generally be bad news knowing that the Ninth Circuit Court of Appeals, but sometimes, it works out okay. We'll see. Nevertheless, congratulations to the people who won this case. And again, if you haven't followed me on X at 4boxes, you really should do so because I get out additional Second Amendment information every day beyond my videos. And don't forget to subscribe and resubscribe here. We're really working hard to try to get to 150,000 subscribers. We're pretty far behind the other Second Amendment YouTubers out there, and we applaud them, and they do great work. But we are trying to catch up a little bit as best as we can. So we'd appreciate the subscription and helping other people subscribe as well. And again, we hope you enjoyed this show, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.